The Federal High Court in Abuja has fixed April 8 for ruling on a preliminary objection filed by the detained leader of the Indigenous People of Biafra, IPOB, Nnamdi Kanu, challenging the validity of the 15-count amended charge filed against him by the federal government. Justice Binta Nyako fixed the date after Kanu's counsel, Mike Ozekhome, as well as the prosecution counsel, Shuaibu Labaran, concluded the adoption of their agreement for and against the defendant's preliminary objection. Arguing on the preliminary objection, Ozekhome asked the court to dismiss the charges against Kanu on the grounds that they are defective and baseless.
All the 15 counts in the charge are bad, and bad. Like I described it before the court, they are as dead as dodo. All that the court requires is to give them a decent burial, because there is nothing whatsoever in the counts at all. You are accusing Nnamdi Kanu of making some broadcast. You didn't say where this broadcast was made. Was it made in the spirit world? Was it made in the air? Was it made under the ground? You didn't state, because the Federal High Court Act says specifically, Section 34, that you must state the very location, specific location where an offense has been committed. That is one. They couldn't state any. They say made broadcast, and that the broadcasts were in furtherance of some treasonable acts. For you to charge a person with furthering treason, you must have to charge the person with treason. Nnamdi Kanu is not charged with treason here. We call it the predicate offense. It is from this predicate offense that the acts of furthering will emanate. So they are.
The prosecution counsel, Shuaibu Labaran, vehemently opposed the application, citing Section 32 of the Terrorism Prevention Act to counter defense argument that the Federal High Court in Abuja lacks the jurisdiction to hear the case.
We take steps to bring to the attention of the court the relevant provisions of the law that suggest that this charge is well-founded and it is filed appropriately and filed at the right place and in accordance with the extant rule and the law that guides the procedure of this honorable court. And we hope and believe that this is one offense that is captured in the open space, is proving all the counts in this charge, requires no any effort. It is one charge that within a twinkle of an eye, if the trial is allowed to continue, it will be concluded within record time.
After listening to both lawyers, Justice Nyako adjourned to April 8 to rule on the application. Basil Okafor, CNA News.